we must all learn to become professionals. Being professionals means
yes.
you
What
must
does
act professionally. Sir, in case ನಾನು ಗೆದ್ದು ಕೊಟ್ಬಿಡಿ ಸರ್, ನಿಮ್ಗೆ ಅರ್ಧ ಜಮೀನು ಕೊಟ್ಬಿಡ್ತೀನಿ. These things we should not do. A person who's fighting a litigation worth 100 crores, right? Why should that person crib to pay a lawyer's fee?
Because see, today we are having so many lawyers. How do you think we can reduce pendency in courts? ನಾವ್ಯಾಕೆ ಕಷ್ಟ ತಗೋಬೇಕು, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡ್ಲಿ, ಆಮೇಲೆ ನಾವು ನೋಡೋಣ. So what do you think, sir, that should be the changes that you want to see in our profession?
I think first thing is we must all learn to become professionals. Being professionals means
Yes.
you
What
must act professionally, which means you must respect each other's time, you must respect the client, you must be clear about what you're going to charge, no success fee in any type of case. Many times, every day clients come and ask, sir, in case ನಾನು ಗೆದ್ದು ಕೊಟ್ಬಿಡಿ ಸರ್, ನಿಮ್ಗೆ ಅರ್ಧ ಜಮೀನು ಕೊಟ್ಬಿಡ್ತೀನಿ. These things we should not do.
We have to make it very clear that this is not.
Whether you win or you lose, I don't depend on that. This is my professional fee, please pay me this, that's it. Secondly, in India, I'm sorry to say this, clients feel that lawyers' fee is not justified. Now, a person who's fighting a litigation worth 100 crores, right? Why should that person crib to pay a lawyer's fee? And many times they say, "Nam friend oru, I just had a transaction with him."
Correct.
I said, we didn't have anything in writing. I gave so much cash. This type of arguments they come up with. So I always tell them, Nodi, that day if you had gone to a lawyer, you would have probably paid 1 lakh rupee fee something.
You would have saved so much.
Now you're going to be spending 10 lakhs and you don't know the result. So you have to be the person who controls your thing. Don't do things without taking advice. I'm shocked, Many people do it. They just go and sign some document without understanding what it is.
No, they don't. I think they only think like when you have a doctor, like how you have a family doctor. Now I think that has come down because everybody feels they are themselves quite equipped to take their own decisions and how to draft and how to exchange agreements, how to exchange emails and write. Yes, I think that is a very valid point that you pointed out.
Another peculiarity I find is, among the various business entities in India, except those who are multinational or overseas companies or very large corporates in India, they have a standard good legal department with qualified people there who are conversant with law, and they are able to properly guide and advise the management guys in the company. But same time, this semi-organized and the smaller group of companies, they just don't bother. I tell them, what you're spending so much, how many employees you got? You got say 200 employees. Can you not have 2 more employees who are going to look after
all
and
the legal
ensure
work
that you don't have problem with 100 employees? ಅವ್ರಿಗೇನು ಸರ್ ಕೆಲಸನೇ ಇಲ್ಲ, there is no work for them, we have industrial peace, they say. Why should I have a personal officer? No, they don't realize it, that there are million laws to be followed, returns to be filed,
so many compliances to be made,
given, so much compliance to be done. Who is going to do all these things? So the importance given to in-house lawyers is very low. Of course, slowly it's changing, but it's changing only in the big and the large corporates. Otherwise,
but not in small business houses. And that should be, because see, today we are having so many lawyers. How do you think we can reduce pendency in courts?
My simple answer to that question is, if government pulls up its socks and decides that it will ensure that its officers don't do wrong things, the problem of arrears in court will get resolved. In 1 year's time will get resolved. Government must ensure that it is not contributing to the litigation. How many cases we see, application given, not considered, come to court, mandamus sir for consideration. How many cases?
But the explanation that is always given is navya kashta tagobeku, court order kodli amel now nodana.
So
How to break this?
This has to be tackled at government level. This is a governance problem, deficit. At the executive level. Now another thing is, in hotly contested huge stake matters, the officer knows that what he is doing is wrong. But nevertheless the officer will say, sir, Nanak Beda, I don't want to be faced with any inquiry before my retirement. Therefore I am writing this order.
So let the court decide. Whatever court decides that we will do.
The solution for this problem, it has to come from the top level of government. They have to apply the mind. What can we do to reduce the number of appeals? Now, many years ago, in the ONGC case, Supreme Court found that large number of litigations are there between public sector companies and government bodies, like tax department, company law department. So they gave a direction that cabinet secretary must constitute a committee, and no public sector company can go to any court of law till that committee examines the dispute, because it's two public sector.
Okay.
So there's government and public sector and a private person or another public sector. So in such a case, why do you want to come to court? That judgment was in force, and for many years it was there. But slowly what has happened now is that is whittled down, and government will go to court for anything. Even, in fact, very interestingly, tax law. You see, in the past, appeals would go from ITO to CIT, commissioner, from commissioner to income tax tribunal, from tribunal go to on reference to High Court, High Court to Supreme Court.
Yeah, it used to be reference, now it's become appeal.
So this was the route.
Correct.
Now, the discretion as to in which case you should file appeal. Suppose the tribunal level.
No, they are filing in every case that they lose in tribunal, the department files an appeal.
Now, to put a cap on that, they amended the law to say that if the stakes involved, the tax component involved is below a certain limit, no appeal should be filed.
Correct.
If appeal is filed, it will not be entertained. So on that basis, many cases went out. Now, like this, can they not do an administrative review? Suppose an arbitral award is given, right? It is given by 3 judges of the Supreme Court, let's say, former judges Supreme Court. There is some challenge to it. Now, instead of waiting for the challenge court under section 34 to decide it, can the government not effectually order a mediation,
and
get a top committee to look into it, get an outside expert to sit on it to say, you advise me whether this claim is tenable. Supposing they advise, okay, this 100 crore claim is there, 60 is tenable, 40 is not tenable. Then the contractor on the other side will be told, look here sir, we think it is 60, you think it's 100. If you want to settle it for 60, I remember one case, it came before Justice K. Swami, he was the tax judge then. It was a matter relating to central excise. What had happened was, the commissioner, then he was called collector, had to decide a case. He had issued a notice and the hearing date had been fixed. Once the adjournment was sought and given, second date when the case was listed, the lawyer while coming to the court had a scooter accident and he couldn't appear.
Oh, okay.
He was not seriously injured, but he couldn't appear. And then this was informed that this is what has happened, please see, give accommodation. Collector said hearing closed. And 2 months later, he passed an order demanding some huge sum of money. It's in the early 80s, from 70-80 lakhs of rupees. Then there's an appeal against that. Okay. So if you file an appeal, they required you to pre-deposit the amount.
Oh yeah, some 50%.
So we don't have money to pre-deposit. No, pre-deposit the
entire whatever. Okay.
So then we decided to file a writ petition. It came for Justice Swami, who was not very familiar with tax laws, but he's a good judge. So it went on for some time. Judge was not inclined. He said, why you come here? You go to appeal. My senior argued the matter, and it must have taken at least 2 to 3 hours to convince the court that here is a case where earlier adjournment granted is not relevant. Today what
on
happened
that day
is
what
relevant.
happened, correct.
He wouldn't agree. So very reluctantly at 4 o'clock in the evening, he said, okay, you take out notice to Central Government Council. We'll see. Mr. Shivshankar Bhatt, late Justice Shivshankar Bhatt, he was the standing counsel.
For the central government.
So we served him copy, next day he came. And I thought yesterday seniors argued on whole day, he's appeared today so he will take time. So I went for the case. So judge asked him, Mr. Bhatt, there's an appeal against this order. So should you not send it back? He said, no, my lord, please allow this writ petition. Because obviously what he has done is wrong. He should
On
not
that
have
day he
done this.
wasn't there.
He was not there for good reason. In the previous day he was not there, it's different. Oh, you are conceding that this order is wrong? He said, as an officer of the court, I am telling you, this order is not sustainable in law. Okay, I am not conceding on behalf of the person who passed that order. But as an officer, I am telling you, and you may please pass the appropriate order. Here's like a slap.
No, I think these
And
are
he
all.
allowed the writ petition.
No, I'm so glad that you read. I mean, you can. I think.
No, judges also mold it. You know, when they realize. See, in fact, I was reading the article in VAKEELA VAAHINI about Mr. K.G. Raghavan in one case.
Yes.
So it was a very interesting anecdote that Ajay Nandalekhe has referred to. There was a case which was against him, and they had not noticed it. So when going to court, they noticed it. So I was wondering what Raghavan is going to do. Whether the judge will raise it, he may not remember it. Mr. Raghavan said, no, this is the problem. This is judgment like this. And this judgment says that I am not entitled to relief. It's my duty to inform you. So this is my predicament. Then the judge said, he saw that judgment. And he felt that that was not correct view. But that's a larger bench, division bench. So he can't do anything about it. So then the judge realized it. And what he said is, I'll do one thing. I will now ask the authority concerned to hear you and pass a fresh order. So on those lines they got that relief. But the thing is, you have to be clear and tell the court.
As to what are the difficulties against me, where do I stand? So a little bit on the lighter side. When I was a student and then I came to court. It was, I think I heard a very stern person like you had a love marriage. So, so why don't you talk about that? So how is it?